Welcome to the 6th episode of the Divorce Law Monitors webinar. We are thrilled to have everyone here today. Thank you for joining us and taking some time out of your day. My name is Robin Lynch Nardone, and I'm joined by my partner, Elizabeth Crowley. Today, obviously, we're going to be talking about prenuptial agreements and postnuptial agreements. If you have any questions as we go along, feel free to drop them into the chat box at the bottom, and we'll try to get to those either during the presentation or at the end. So before we dive in, let us introduce ourselves. Elizabeth, why don't you start?
Sounds great. Thank you so much, Robin. Good afternoon to you all, and we're so delighted that you could join us and take time out of your busy day to learn about prenuptial agreements and postnuptial agreements. My name, as Robin indicated, is Elizabeth Crowley. I am a partner at Burns & Levinson in our private client group in our divorce and family law department. I've been at Burns & Levinson since 2006, and I've never left. And I've practiced with Robin for all of the time that I've been at Burns & Levinson, and we've been law partners for some time, and both of us routinely, as part of our practice, draft prenuptial and postnuptial agreements and occasionally get to litigate them as well. Thank you, Robin.
Okay, so I'm the chair of the Divorce and Family Law Group here at Burns & Levinson. I have been here for over 20 years. I won't say how much over, but over 20 years. In addition to being a divorce litigator, I also, as Elizabeth does, have extensive experience drafting prenuptial and postnuptial agreements, as well as litigating the validity of those agreements. I participated in the drafting of the appeals brief in the case of Anson versus Craven Anson, which was the 2010 case that set the enforceability standard for postnuptial agreements in Massachusetts. So with that, we are ready to jump in.
Excellent. Thank you so much, Robin. So prenuptial agreements are valid and enforceable in Massachusetts. The law is Mass General Laws, Chapter 209, Section 25. And a prenuptial agreement is sometimes called an antenuptial agreement or a premarital agreement. They all are one and the same. It's a written contract that is signed by both parties that are intending to marry, which sets forth their financial rights and obligations in the event that the marriage is terminated by death or divorce. Some individuals are desirous of having a prenuptial agreement that deals with both divorce and death. Some clients, depending upon their unique circumstances, may simply be interested in having a premarital agreement deal with divorce or death. And all of those are options, and obviously, depending upon the client's circumstances, we determine what would be best for them. For a prenuptial agreement in Massachusetts to be enforceable, the standard is that it has to be fair and reasonable at the time of execution. In the event that a prenuptial agreement is ever contested in the future, whether in the unlikely event of divorce or death, the contesting party must prove that they've been, must have been fully informed, or had independent knowledge of the other party's income, assets, and liabilities prior to the execution of the agreement. So some of you might be wondering, how does that happen? How that happens is that as part of a prenuptial agreement, we complete very detailed schedules containing the income, assets, and liabilities of both of the parties. And this is probably the single most important facet of a valid prenuptial agreement, because it is critical for both parties to know what the other side's financial circumstances are, their income, their assets, and liabilities. And the reason for that is that there are very important rights and obligations that may be being waived when you're being asked to enter into a prenuptial agreement. And so when we are negotiating a prenuptial agreement, we are always advising clients and discussing what would your rights and obligations be in the absence of a prenuptial agreement, whether in the event of divorce in Massachusetts or in the event of death. And so we are constantly talking about that so that a client can not only understand what their rights and obligations would be absent a prenuptial agreement, but also so that they are fully informed with respect to any waivers of any rights and obligations that they may be making. And so that's really important. Sometimes individuals may say, I know I'm going to receive a huge inheritance, but my parents don't discuss it and I'd rather not put anything. Is that okay? And it's always really important, even if it's uncomfortable and you have to stretch, to really make certain that those disclosures are as thorough as possible. And in the event that a prenuptial agreement is contested, a second look is required. And so while the agreement itself must be determined, if contested, to be fair and reasonable at the time of execution, in the event that it's contested, it also must be determined to be conscionable at the time of enforcement. And so that's the second look that we as practitioners speak about and the case law supports. Back to you, Robin.
Okay, thank you, Elizabeth. So what is a postnuptial agreement? A postnuptial agreement is also called a marital agreement, and that is a written contract signed by spouses who intend to remain married, and that is an important piece of it. This is not a document that you are taking to the divorce court to proceed with the divorce. You have to have an intention to remain married. Similar to a prenuptial agreement, this is a contract between the parties that allows them to set forth financial rights and obligations in the event of a termination of the marriage, at divorce, at death, both or one or the other, as Elizabeth said with the prenuptial agreement. You can also include financial provisions relating to what's going to happen during the marriage, and we'll get to those as we get further along in the presentation. So postnuptial agreements are valid and enforceable in Massachusetts, and that was determined in 2010 under the case of Anson versus Craven-Anson. In terms of enforceability of a postnuptial agreement, the court is going to look at this a little bit closer than they look at a prenuptial agreement. First of all, each party has to have had an opportunity to obtain legal counsel. This is very important. And while the case law says an opportunity to obtain counsel, we always tell our clients both sides must have counsel, not just understand that they could have done it and say, no, thank you, I'm not interested. It is very important, particularly if there's going to be a disparate division of some of the assets, that each side consulted with counsel before proceeding. There can be no fraud or coercion in obtaining the agreement. And just as with a prenuptial agreement, there has to be a full disclosure of all assets, liabilities, and income before execution of the agreement. As Elizabeth said in the prenup, this is also critical in a postnuptial agreement. Parties need to understand what rights they may be waiving in walking away from particular assets, and they can't do that if there was not a full disclosure. A postnuptial agreement is required to have within it a knowing and explicit agreement to waive the right to a judicial equitable division of assets. And for us, that means we include that language in the prenuptial agreement, and both parties read it and sign it and understand that they're waiving their right for a judge to divide their assets in the future in the event of a divorce. Now, here's where we have the difference between a postnuptial and a prenuptial agreement. The terms of a postnuptial agreement have to be fair and reasonable at the time of execution, and fair and reasonable at the time of enforcement. Fair and reasonable is a different standard than what Elizabeth just talked about as being conscionable. Fair and reasonable it's a little bit technical, but the court has said that because people signing a postnuptial agreement are married, that these circumstances are pregnant with the opportunity for one party to use the threat of divorce to bargain themselves into a position of advantage. I smirk because I just find it a little bit humorous that they use the word pregnant in a marriage. Anyway, because of that, there's a fiduciary relationship between a husband and a wife in entering into this contract. The court is going to apply a tougher standard when they're looking to enforce a postnuptial agreement. So that means the court is going to look at what is it that the objecting party is objecting to? Why are they having a problem with this agreement if one party is seeking to have it thrown out? What are the financial and property division terms within this agreement? Are they fair to both parties, and fair when you signed it and fair now? Which is similar to how a separation agreement, which is our divorce agreement in Massachusetts, is enforced. The court is also going to look at the context of the negotiations that took place. Was there undue pressure on one party? What were the circumstances of the lives of the people at the time? Was there a health issue? Was there something of that nature happening? They're going to look at all of those circumstances. How long did the negotiations take place? Was it 5 minutes? Yes, I'll sign it. Or did it take place over months of time? Were the parties living together at the time? Were they living apart? Was there a pressure of I'll only come back and live with you if you sign this? So all of that goes into what the court considers. The court will also look at the complexity of the issues in a postnup, where they're not going to look at that necessarily in a prenup. So something very complex, if there's someone with a complex compensation structure and someone's waiving rights to alimony, did that person understand the complexity? And how long you negotiated in a more complex situation is going to be important as compared to a simple W-2 employee, perhaps, or they have simple assets that are just held in accounts and they're not structured investments. Then the complexity is less, the court's going to have less concern about the agreement. They're also going to look at the background and knowledge of these parties. If one of them is a lawyer and one of them, didn't graduate high school and they're negotiating together, the court's going to take that into consideration. They're also going to look at the experience of the counsel involved. So you don't want a real estate attorney helping you or your client prepare a prenuptial agreement. If the counsel was not experienced, that may weigh in favor of the person seeking to throw out the agreement. So you want to make sure, if you want this agreement enforced, that at the time it's being contracted, both sides have quality experienced counsel who have written these agreements in the past. The court also will look at whether the parties needed experts to be involved. There is no obligation, definitely not under a prenup, as Elizabeth was talking about, that you get expert evaluations, but sometimes things are so complex that the court would want to know, did you understand it and could you have used an expert to help you? So this has gotten a little bit technical and a little bit dry, but I'm going to pass it back to Elizabeth, and she's going to talk about when it is that a prenuptial agreement might be right for you.
Thank you so much, Robin, and that was great. Just to dovetail, Robin, on some of the points that you mentioned with respect to the post-nuptial agreements that I think are issues that come up with respect to prenuptial agreements, is the opportunity to have counsel. Oftentimes with prenuptial agreements, one of the questions that I get asked a lot is, does the other side need counsel? Oftentimes, the individual coming to me will be the individual with the wealth to protect, whether it be income, premarital assets, inheritance expectancy, or some blend of the three. And as many of us can imagine, sometimes when a couple is to be married and they're excited and they're engaged and they're looking forward to these things, sometimes they don't want it to be a pressure cooker situation or uncomfortable. And certainly, even though we're dealing with really important rights and obligations, we try to make it as straightforward as we can and conflict-free, and ultimately get it done well in advance of the wedding. I will not do a prenuptial agreement without the other side being represented by counsel. It just opens up an agreement, in my opinion, to too much risk. And so there may be people out there that will do that. I don't think it's best practice for a prenuptial agreement. And so I think it's really important, even if you're an advisor or you have, a client, or you are the client, and you think, well, that's okay. They understand these things and we've talked about it a lot, and they don't have the money for an attorney and they don't want to get an attorney on their side. We're just going to get this taken care of. It is critical that both sides are represented by competent counsel so that they're receiving independent advice, and that protects the integrity of the agreement. I tell clients that all the time, especially those that just say, oh, it might be an added layer that we don't need or an added cost. And I say it's probably the single most important thing you can do for the integrity of an agreement, to make certain that the other side, typically the party without the wealth and the one that is making perhaps very significant waivers of rights, have independent counsel. And just the second question before I go into the types of circumstances where a prenuptial agreement might be appropriate is, how soon in advance of a wedding do we like to see clients come to us to start preparing and negotiating and drafting a prenuptial agreement? And I typically say more lead time is better. You know, there are certainly circumstances where people want to do it last minute. I don't think that's a good practice. It's not one that I will do in my practice. And I've had clients come over a year in advance, which is delightful, organized with their thoughts and what they're looking to accomplish. And that makes the entire process, in my experience, streamlined. It's not rushed. The other side cannot potentially down the line say that they were rushed, that the rehearsal dinner was a week later and the wedding was coming up and all the invitations have gone out, and that the advisors are able to do what we need to do without any types of deadlines, needlessly pressuring everybody. And so if you are an advisor, giving advice to clients, as soon as possible. And even if they don't know whether or not they need one, have them reach out to competent counsel to have that initial discussion. I've certainly said to individuals going over their circumstances and weighing all of the risks and potential eventualities that I didn't think it was necessary for any number of reasons. And certainly there's more often than not, I am telling individuals for any number of reasons that it would make good sense for them to consider doing so. And so what are the types of clients and individuals that may benefit from a prenuptial agreement? We're seeing certainly in our practice a ton of prenuptial agreements, much more than I even saw 15 years ago in my practice. A lot more people are sometimes getting married later in life when they have careers, sometimes second marriages, when they've accumulated assets and income and have obligations to adult children and otherwise. And so, beyond a second marriage, situation, and it may be that both parties are getting remarried and they have, they're coming from a situation where they have children from a first marriage or relationship, and they want to make certain that their estate planning dovetails nicely into the prenuptial agreement so that everybody's rights are known and their estate planning is consistent with what their respective desires would be. We see that a lot. Individuals coming together where they've accumulated wealth and they have a nicely integrated estate plan, typically with wills and revocable trusts and the like, and they want to make certain that everybody's expectations are aligned with respect to their desires as far as benefiting children and other individuals upon their death. And certainly, when there are significant premarital assets, oftentimes, and it's amazing, I will see sometimes very young individuals that are getting married that either have significant family wealth, sometimes in the hundreds of millions of dollars, for any number of reasons, whether from closely held family businesses, whether wealth generated from their own employment and profession. And certainly there are sometimes situations where one individual may not have a lot of accumulated wealth that they've accumulated prior to getting married, but they may be earning significant income. I've seen situations where one party may not earn a lot. They might be at home with a child or planning to be at home with a child, and they may, perhaps the most they've ever made is $30,000 or $40,000 a year, and that's fine. And the other side may make well over $1 million a year, and perhaps is coming from a divorce, and perhaps it's a first marriage for the individual that they're marrying. And so every situation is unique. Oftentimes, there may be someone that wants to protect their family wealth. They may be one of several siblings, and sometimes you see a situation where the family patriarch will say, we have 4 children, we have significant wealth, we are requiring all of our children to enter into a similar prenuptial agreement so that that family wealth is protected in the event of divorce. And then sometimes you'll see competing interests on the other side where they may not have any expectancy of an inheritance. They may have 0 premarital wealth. They may even have student loans from education, but they're making several millions, and they may have compensation that is complicated. They may have RSUs and all different types of compensation that they're looking to protect, or perhaps even a very real expectancy of an upward trajectory in their compensation at their company. We've certainly seen situations where an individual might not be earning much at all, but they have a startup. And the expectation is that startup is going to take off and that there may be an acquisition down the line, or they may go public. And so all different types of circumstances, and finally, sometimes a married couple or a couple getting married may have very different views of spending, saving, and debt. And so sometimes we will get very specific in prenuptial agreements, identifying what assets are premarital that are going to be protected as separate property, what assets and income on a forward-going basis will be marital property, and how certain buckets, for lack of a better word, of income and assets can be used during the course of the marriage so that expectations are set. I've seen clients get detailed with respect to whose money and sometimes in what proportions is going to be used to acquire a marital home or a vacation home or any other types of things that come up. And, first instinct can sometimes be, oh gosh, just going into a marriage that seems, rather, specific to be getting into that level of detail. But depending upon the circumstances of the couple, very often it sets expectations and eliminates conflict going into the marriage, which can be desirous for one and hopefully both. Back to you, Robin.
Okay, so who would be right to get a postnuptial agreement? So a postnuptial agreement is often signed where their parties are having financial issues that is damaging the relationship. The goal of this contract is, of course, to keep the marriage intact by eliminating these financial issues so that there can be no continued disagreement and both parties are feeling safe and secure financially in the ongoing relationship. It could be that suddenly, one party has an expectation of inheritance that they didn't, think about prior to the marriage, and to avoid disputes about what's going to happen with this money, or if someone wants to be sure, I want to be sure you're not going to take this away from me, you're not going to divorce me and take away half my inheritance, and so they want to have an agreement about what's going to happen with monies or assets that are coming their way. There could be a disagreement about a major purchase. For example, one of the parties wants to take a significant chunk of a cash asset and invest it in something risky, and the other one does not. And they want to work out terms that say, okay, if we have $1 million, we're going to split it now. So you can take your 500 and invest it in this risky thing. And if you lose your money, that's your problem. I keep the 500,000. So those are, there can be many kinds of issues over a major purchase where people can resolve that and take it out of their marriage as a dispute so that their marriage can continue. There can be disagreement over spending or debt. For example, I had a case where one of the parties had a gambling issue. So there was debt being incurred and spending of assets, and one party wanted to protect themselves from that debt and from that spending. That was the goal of the postnuptial agreement in that case. The issue with disagreements over spending and debt, where I caution people, is remember that you have that fair and reasonable second look in a postnuptial agreement. And so if you've split up all or certain assets and the spender or the gambler has now reduced that down to zero, and the saver has taken their 500,000 and turned it into $1 million, and it's 10 years later, is the court going to say it's fair and reasonable for this one person to leave this long-term marriage with zero because they had a spending problem? Possibly not. So that's a caution about dividing assets through a postnuptial agreement during the marriage, because there has to be something that's going to go to that other person and they're not walking away with zero. A career change and worries about the future are also circumstances where sometimes people want a postnuptial agreement. For example, one party doesn't want to become a stay-at-home parent without assurances that should this marriage fail, there's going to be an alimony component. Or the opposite, I don't want you to become a stay-at-home parent unless I'm sure you're not going to come after me for alimony. The typical is not one of these items. It's usually more of a global, let's look at everything and what can we do to resolve our financial disputes. The final reason that people enter into postnuptial agreements, from my experience, is where they planned to do a prenuptial agreement, and with the planning of the wedding and everything else, it didn't happen. This is not recommended. If someone comes to me, you know, 2 months before their wedding and says, well, if we don't get it done, we'll just do a postnuptial agreement, right? And I say no. Remember, you have that standard that is different. A prenuptial agreement is negotiated before you are spouses, so you don't have that fiduciary relationship to one another. And also, your positioning is different after you are married. You're already married. What is one person going to do if the other will not sign that postnuptial agreement? Are you going to get divorced right then and there? Perhaps. With a prenuptial agreement, you have, you know, your wedding is set. It's kind of a deadline there, and it forces you to take the steps to get that done, because if you don't get it done, perhaps you're not going to be getting married. You don't have that deadline for a postnuptial agreement, so it becomes both harder to get maybe someone who's reluctant to get it completed, given there's no deadline in the future. So my advice, and Elizabeth's is the same, is always, if you want a prenuptial agreement, get it done. If the time is a problem, push out that wedding. Get it done, because it's, I don't want to say easier to enforce, but because of that standard, it can be easier to enforce. And so if you're thinking about a prenuptial agreement, you have clients who are thinking about prenuptial agreements, get it done before the wedding, because a postnup is really not just, we couldn't get to it, let's do it after we get married. Okay, back to you, Elizabeth.
Thank you so much, Robin, and all helpful advice. And I thought of two things before we get into issues to consider for a prenuptial agreement. One, with respect to timing, just to dovetail on what Robin said that I've been getting a lot, is in COVID, with the ongoing pandemic, obviously, there's been many weddings that have had to be postponed and rescheduled again. And so one question I received from a client recently, and it was a good one, is that they had decided to postpone their wedding, their celebration, until next year. Really nice young couple, but they wanted to get married, and they were going to go to City Hall and actually get officially married, but not have the celebration until next year or whenever it was safe to do so. And so they wanted to know if that was okay before they got everything signed. No, it's not. And so it's one of those things, it may seem like splitting hairs or not that important. You know, it's just a piece of paper, as they say, going to City Hall, but it has to be done before you legally get married. And the timing is really important. And again, as Robin was saying, and I was saying before, the more lead time, the better. I've seen certain circumstances, sometimes for very good reasons, where people want to speed things up and just get it all done in a short time frame. And there's obvious risk associated with that. And so it's not best practice. It's not ideal. Sometimes clients go forward with the advice that we give them anyway, recognizing the risk and being able to accept that risk, but it's not ideal. So the more lead time, the better. And one other point as well, Robin and I both obviously are divorce attorneys and practitioners and litigators. And one of the benefits of that, when we are drafting, advising, negotiating on prenuptial agreements and postnuptial agreements, our minds are always going to that second look stage, to that next stage in the future. And while none of us has a crystal ball, I wish we did sometimes, and knows exactly what's going to happen in any number of circumstances, we are able to be really strategic and forward thinking and identify and spot issues for clients that they otherwise may not recognize or be able to appreciate. We're able to speak about the alimony laws here in Massachusetts, the equitable property distribution laws here in Massachusetts, both in the event of divorce. We're able to speak about the estate rights in the absence of an estate plan for a married couple, in the absence of a prenuptial agreement that may provide otherwise for those rights and obligations. And that's really important for a few different reasons. One, it helps to inform our clients' decisions, and they're able to make knowing waivers and decisions with respect to any number of rights or obligations. And also, when we are thinking, would this be fair? would this be unconscionable, or to the contrary, would this be unconscionable? We're able to give some examples, and we're able to walk a client through any number of examples to say, okay, if you have this now and this grows to 3 times that, would this still be deemed likely conscionable by a court if this was challenged? And one of the things that comes up most often that I will see in prenuptial agreements is a sizable amount of wealth is looking to be protected. And sometimes a client may come in and say, I just want a very simple prenuptial agreement. What's mine is mine. What is the other side's is the other side's. Full alimony waiver, and we'll simply waive all rights in one another's estates, and we'll allow our estate plans to control. That might sound fine, but if you have a set of circumstances where you fast forward 10, 15, 20 years, that young couple, maybe there was $10 million of wealth, and now all of a sudden you have over $100 million of wealth, and now you have several children, and now you have the party without the wealth not working and built into a lifestyle. And then all of a sudden the other side may say, well, all marital property is to be split equally, so that's totally fair. We don't need to worry about this. And then you look at what they've accumulated by way of marital property 10, 15, 20 years later, and you see there's $1,000 in the joint operating account. That's a problem. And so we draft really strategically to deal with issues like that, obviously advocating for our client and getting the best possible prenuptial agreement in terms that we can, but also making sure to insulate the client against the risk of that potentially being challenged in the future. And I always tell clients, in order to garner and get the protections that you're looking for, you have to give something up. And so when you're thinking, and that can mean any number of things, but, in the situations where everybody wants to keep their wealth and not give anything or give $1,000 in the event of divorce, that's typically not going to fly unless the other side has significant wealth of their own right. And so with that said, what do prenups deal with? What are the issues to consider for prenups? We deal with allocation of assets and liabilities in the event of divorce. We deal with asset and liability allocation in the event of death. And as I said at the beginning, sometimes clients will only want to deal with one or the other. Most often I see clients looking to deal with both. Right out of the gates, we deal with what property is going to be separate property, what property, if any, is going to be marital property. And we define with a great level of detail what those categories of assets are, and obviously make certain that the asset and liability schedules are very detailed so that there's no question with respect to the property that either or both parties are bringing into the marriage. We deal with alimony. Sometimes it's a situation where the parties want to completely waive alimony. Neither party shall be entitled to alimony in the event of divorce. Sometimes there's a waiver on one side, but not the other. And sometimes we actually deal in a great level of detail with formulas, definition of what gross income is, and oftentimes we will deal with the Alimony Reform Act, which is our law here in Massachusetts. It went into effect on March 1st, 2012, and we will go over in great detail with a client that's looking to eliminate or limit their exposure, how we can accomplish that. And on the flip side, when a client is looking to make certain that their rights are protected, or that their rights are clearly defined in the unlikely event of divorce, where they would potentially be a spouse that would be on the receiving end of spousal support, we make sure to do that as well. We deal with health insurance and life insurance obligations in a prenuptial agreement. We deal with taxes. Sometimes parties entering into a prenuptial agreement decide for any number of reasons that they're going to file separate taxes while they're married. Sometimes they decide that they are going to file joint income taxes, but they want to make certain that they apportion any of the income tax refunds or any liabilities owed in a way that is consistent with the rights and obligations that they've agreed to under the prenuptial agreement. So as you may imagine, it can get very technical and complex, and we deal with all of that. Some parties will be interested in having conduct clauses in a prenuptial agreement. Those are always interesting. And, you know, I have had clients that have wanted a clause in there that if one party is unfaithful to another, you know, certain rights shall be, you know, given up. And I typically, with very few exceptions, will caution and advise clients with respect to those clauses. You know, the more detailed they get, sometimes they are not enforceable and void against public policy. You know, I also will say to clients, depending upon what they're telling me, certain things are very hard to prove. And so I don't want them being set up in the event that there is a divorce for litigation over what does that clause mean? Was it enforceable? Is it void against public policy? And usually there's other ways to probably deal with the client's concerns, short of having clauses in a prenuptial agreement that might not be fully clear with respect to the intent and any penalties, so to speak, for an offending party. And finally, prenuptial agreements sometimes will get into detail regarding contribution to expenses, future acquisition of assets. Sometimes there might be a situation where one party has elderly parents that they want to provide for. And sometimes another party may not be in agreement with that, but they want to find a way to support that. And certainly sometimes there's obligations that either side may have to children from a prior relationship or relatives overall. And sometimes, as Robin mentioned, there's just a difference of opinion with respect to expenses and spending. And it may be a concern for one party. It may be a concern for the party that's coming to the marriage with all of this wealth, thinking, oh gosh, as much as I love my soon-to-be spouse, they are a spender. I am not. I am more conservative, and I need to make certain that we are not going to be, you know, draining all of our assets on, you know, expenditures that the other party may not feel are needed or consistent with their habitual spending. And so again, it's all unique to individual circumstances, and typically when we draft a prenuptial agreement for a party, very rarely does that initial draft end up getting signed off on. There's almost always changes and revisions, and while the negotiations are ongoing with the other side, and we work to be able to deal with the interest on both sides for any number of terms, typically revisions are made, and that's completely normal. And I always reassure clients at the beginning of the process that that's to be expected, and they don't need to worry about it necessarily. Back to you, Robin.
Thanks. And I would add to that what Elizabeth just said, that you want revisions because you want the other side to have participated in the process in a knowing way. And if they just sign off on the first draft that is sent over, that potentially is a red flag that there was no negotiation, they didn't speak to a lawyer, they didn't understand what they were signing. So never worry about revisions coming from the other side, because that certainly is expected. So with a postnuptial agreement, I'm not going to go through all of the considerations again, because they're nearly identical to what Elizabeth has just gone through very well. You, in entering into a postnuptial agreement, are looking to take yourself out of our divorce statute with regard to equitable distribution in dealing with assets and liabilities, and potentially out of our alimony statute if you're dealing with alimony provisions within your agreement, as well as our estate laws relative to what a spouse is entitled to receive under an estate. That would be the purpose of this document, is to lock those things in and take yourself out of the statute. Again, health insurance, life insurance, taxes, contributions to expenses, particularly in a postnuptial agreement. Sometimes you see this more than in a prenup. If part of the issue in the marriage is that I'm spending all of my income to meet our expenses and you're spending yours on frivolous things. And so sometimes people want to include provisions that say each is going to contribute X% of their income towards whatever it is, the mortgage, the household expenses, those types of things. Those things can be tricky. Again, what is your enforcement? How do you enforce these things if you want your marriage to continue? So sometimes you see those things, and sometimes we caution against what is that going to do in terms of your relationship if you're going to be tallying up these things. But that's something that people do include. again, I'm a broken record here, but I'm going to say when considering what you're putting in your postnuptial agreement, you need to think about what is the impact of that second fairness look on the terms that you've come up with, which is different from what the prenup is going to allow you to do. In that second look, the court is actually going to look at what they would consider under a separation agreement, which again is a divorce document. And while the agreement does not have to be what that reviewing judge would determine to be the allocation of the assets or alimony if that judge heard a contested trial, they're still going to look at all of the factors, including what is the length of this marriage, what are the age of these parties, what is the health of the parties, what was their contribution, what is their current income. Those circumstances, particularly if someone has a health issue that makes a dramatic change in what you were thinking 10 years ago when you signed this document, could impact. So we're always, when we're drafting these things, going to be looking at, think about how that might be looked at down the line. Is it going to be fair? And what can we do to adjust those things, even if it's giving more than you want to give right now, so that we are sure that it will be enforced because that fairness has been considered. Okay, Elizabeth, let's tell people what they cannot put in their agreement.
Absolutely. And before I do so, Robin, you brought up something, and you know, one of the most important things after a prenuptial agreement is executed and is in place. And we advise clients on this all the time, and we, you know, really appreciate working with advisors on what I'm about to say. But one of the most important things is you get this prenuptial agreement all set, or postnuptial agreement, whatever the case may be, and the mechanics are whatever they are with respect to how assets are going to be held, how title is going to be held, and then a couple goes on to be married 10, 15, 20 years, and they don't do certain things. They don't title things properly. They commingle separate property with marital property. They start paying off credit cards in a way that wasn't supposed to be done. They start purchasing real estate and using separate property that they may have an initial expectation of carving back out, maybe putting a mortgage on the property later on and making sure to reimburse that separate property that, for example, may have been used as the principal down payment, but yet they never do any of that. And then down the line, there's an unfortunate divorce. We get called, and all of a sudden we look at the prenuptial agreement. We say, this is great. We have a really well-drafted prenuptial agreement. And the client says, and thankfully, this has not happened to me with anything that I've drafted or a client, but you know, you get one, sometimes your divorce counsel, and they say, but the only thing, we didn't do any of this and it's a mess. Can you help me? That's an unfortunate position to be in, and certainly we can help in those circumstances. But one of the most important things is that the mechanics be followed and that it's actually implemented. I can tell you just two brief examples. I had a delightful young gentleman whose prenuptial agreement I just did. He's been such a trooper. His wedding's been rescheduled 3 times, nice young couple. And he called last week when he had a moment to catch his breath with advisors that he has to get all his accounts set up, so that he has separate accounts for everything, and everything's going to be funded appropriately, and post-marriage contributions to 401ks. And he was so organized. I was so impressed for a young gentleman. And just one other quick example, I had a wonderful estate planner who I was working with recently, post-nuptial agreement for a delightful couple in their 60s. They're dealing with some estate planning issues, and the estate planner, just as the couple has been married longer and circumstances in their families have changed, identified some really good ways to save on taxes and any number of things. And we all worked together to do an amendment to the post-nuptial agreement to nicely dovetail into the estate planning that estate planner was going to do. And so those are how we love to work, working with advisors, working with clients, so that everybody is involved and the right hand knows what the left hand is doing, so to speak. And so as far as the prenuptial agreement, what it cannot contain, child custody provisions. Oftentimes individuals will say, well, if my spouse leaves me and cheats on me, I want to make sure there's a provision that our unborn children, or born as it may be, are mine, and I will have child support, and I will any number of things. Those are considered void against public policy. Same thing for child support, the amount, you know, and any provisions related to that. And the reason is that, you know, they're considered void against public policy because the Commonwealth of Massachusetts and our courts always want to retain jurisdiction over anything related to children. They never want children or anything related to children to be a bargaining point in negotiations. And so similar in a prenuptial and postnuptial situation, even in a divorce situation, you cannot bargain away the rights of children and say, I will have custody of child X forever and ever and ever, and that's final and binding and surviving, and you pay me X amount in consideration of that. It's void against public policy and you cannot do it. One thing you can do in a prenuptial agreement, and I've done before, is where you are doing a formula for support and alimony entitlement, you can certainly speak to any future child support obligation would not be double counted, so to speak, with respect to an alimony entitlement. And again, that's technical, but you know, our eyes are on those things to make certain that a client is fully protected in that regard, and certainly on the receiving end as well, depending upon what the circumstances are. Thank you, Robin.
Okay, so postnuptial agreements are pretty much the same in this category in what you cannot include. No child custody related provisions because the court is going to look to what's in the best interest of the children. So, you know, if you agree at year 1, you have a 1-year-old, you know, if we get divorced, I get custody, and at year 15, you have an alcohol problem, the court is not going to uphold a custody provision. It's not in the, you can't determine the best interest of the children before they're born or 10 years earlier. It has to be based on the circumstances at that time. So if you try to put these kind of provisions in an agreement, the court is not going to uphold them. Same thing as Elizabeth said with the amount of child support. Other provisions that are against public policy would be, you can't agree to do anything illegal, whether that's relating to perhaps income reporting or taxes or anything like that. You can't do something like that in an agreement like this. You also can't do something that restricts someone's personal liberty. I would describe that as, you know, you shall be at home and make dinner 5 nights a week, and you can't go out with your guy friends to go play hockey, whatever. You can't do things like that that restrict, that say this person has to live for all time in Massachusetts, things like that. That, again, is also going to be against public policy. I think that's most everything. So let's see if there's, I don't see any questions in the chat box. If anybody has any questions and you would like us to answer those, feel free to put those up, or you can certainly email either of us after the fact. So Elizabeth, any closing remarks of anything you think we should add and that people should know about?
Certainly. So just a general thanks to all of you again for taking time out of your busy day to join us. We love being able to do these webinars and share our expertise. And as Robin said, if you have any questions at all, please don't hesitate to reach out privately to us on email or telephone call. We're always delighted to answer questions and to be a resource. And thank you all very much, and we appreciate it.
Thanks, everyone.